Welcome to the 4-Minute Long-Term Disability Lawyer, a channel where you get straightforward, common sense disability insurance help in more or less 4 minutes. In this video, I am going to explain some key issues regarding denial letters, and also talk about the different types of steps in the administrative appeals process. If you have received a denial letter from your insurance company, here are some basic things that you need to know before you call a lawyer for a free initial consultation. First and foremost, you should know that you have 180 days to file an appeal, and that you shouldn't wait very long to contact a long-term disability lawyer. Ideally, when you call a lawyer, you should know at what stage in the process your case is at. This will help you in obtaining a better free initial consultation. You should also be ready to email or to fax the denial letter to the lawyer relatively quickly. Typically, there are two types of denial letters in long-term disability cases: the initial denial letter and the final denial letter. The initial denial letter is the first notification to an insured by the insurance company that benefits have either been stopped or that the claim is denied. The final denial letter is a second letter that comes only after and if the insured has filed an administrative appeal. However, changes in the regulations from 2018 have made this clear distinction that once existed between denial letters, initial denial letters, and final denial letters somewhat murky. From 2018 on, insurance companies have been required to provide the insured with the opportunity to present additional comments prior to the issuance of the final denial letter. This is an opportunity in between the filing of the administrative appeal and the issuance of the final denial letter that is given to the claimant to provide more commentaries. This change, in effect, has created somewhat of an intermediate appeal step, I should say, between the initial denial and the final denial letter. In this intermediate step, an insured is typically given the opportunity to respond to the opinion or the opinions of the medical and the vocational experts hired by the insurance company. A lot of going back and forth can occur in this intermediate step. For example, the insurance company can decide to request additional medical records, or the insured can decide to ask his or her doctor for a new medical opinion or a follow-up opinion than the one originally provided during the appeals process. This situation can make it difficult for some insureds to understand at what step of the process their case is at. I feel that sometimes this confusion can make it harder for a lawyer to provide a good free initial consultation. I hope that this commentary that I have given you in this video helps clarify the different types of denial letters and the different steps in the appeals process, including this intermediate step that I have described. And more importantly, I hope that this video helps you receive a better free initial consultation from a long-term disability lawyer. If you have received a denial letter from your long-term disability insurance company, you can request a free initial consultation from my office by going to my website, longtermdisabilityappeals.com, or you can call us at 860-519-5242.